everybody, Tim Harrison, Straight Up Mortgage Talk, and today we are so fortunate to have Peggy Hosking from Best and Krieger. She is a partner in that law firm, which is a very large law firm in this area, and she is going to talk to us about vesting, the benefits of some of the different types of vesting, which is like tenants in common, joint tenants, community property, or having a trust. So let's get started and let's get educated. Hey everybody, Tim Harrison, Straight Up Mortgage Talk, and today I am fortunate enough to have Peggy Hosking from Best and Krieger, which is a law firm. She's an actual partner, so we're talking about a little bit above my grade here. So I'm super excited to have her. She did an interview about Prop 19 in California that was super helpful on us understanding those tax law changes. And when we talked, and I wanted to have her on again because she's awesome and so knowledgeable, she sort of said, hey, there's a lot of problems with how people hold title. So today we're going to talk about how to hold title, what's the risk and differences. So Peggy, let's get started.
Okay. Well, then, as you and I had previously talked about offline, sort of the gold standard, particularly when people are buying homes and it's husband and wife and there's nobody else involved. The gold standard is please to have a trust. And I know you've had Mike Ventimiglia on before, and he's talked about trust. And there are lots of wonderful reasons to have a trust. One of the best reasons is so that if you pass, the mechanism to transfer your property as you wish for it to be transferred is already in place. And your poor family doesn't have to now go through a probate, which has fees that are set statutorily. So it's very easy in California to have a probate with $25,000 in fees because the house was worth $750,000. So, or whatever the number happens to be.
As compared to a trust, like 25K, $2,000, because
yeah,
you're talking about putting together the trust. You're not even talking about the execution of the trust. You're just talking about.
No, I'm talking about the whole thing. I'm talking about doing the trust, doing a will for, husband and wife, doing the durable powers of attorney for healthcare and the statutory powers so that it makes it easy for your family when that time comes. Because unfortunately for all of us, we know that time will come at some point in time.
Death and taxes.
So,
can't avoid it, right?
Is a hell of a gift to your family versus having, some of these horrible situations we can talk about later on, but where the property wasn't in a trust and there were challenges as a result of that. If for some reason you can't do a trust, promise yourself that you will do it within a year of buying the property. And for a husband and wife, I would say take it as joint tenants with rights of survivorship. I always think that because as a joint tenant, with that right of survivorship, if your significant other, your spouse, however you guys are together, dies, then you automatically inherit their portion of the property.
Okay, so let me ask you a couple things, because this is why I do these interviews, so I can figure out how dumb I am and then tell people like, hey, Peggy, the smart one, who's a partner in a law firm, actually told me this. Don't hold her liable. Don't hold us liable for any of this information. She is not your attorney and I'm not your trusted advisor. This is information from a partner in a law firm, Best and Krieger, who's pretty up there, just saying, but until you consult with her, you're not her client. So this is just free advice. As my disclaimer. You like my attorney disclaimer?
I love it. Good job. Good job.
You can tell I've been in business for a few years, right?
2 years.
How to protect your butt. So I've always been told that, at least from my CPA uncle, that the husband and wife or whatnot as joint tenants didn't allow cleanly in the tax law, so the step up in the tax bases, and that's why that community law with right of survivorship was created. But you're saying you would recommend people do joint tenants as tenants or joint tenants with right of survivorship, and of course within a year get the trust, because you would hopefully assume they both don't die in a fiery plane crash together and then leave it all for the problem, right? Or for the family. But can you explain? So couple things. One, get a damn trust. Listen to the interview I did with Michael Ventimiglia. I finally had to learn how to pronounce his name. And Peggy and Michael know each other. She listened to that. She's a good estate advice in there, why you would have a trust and how expensive. Again, Peggy's here reintroducing how much more expensive it is. So,
Careful.
and in there, he also discusses not only is it more expensive, but if you don't have anything, then you potentially leave a crap show for your people that inherit it because you haven't clearly defined what you want to happen.
Absolutely.
And so families may not be as tight after your death, which is not what anybody who's leaving this earth is hoping for.
Right.
So you can clearly say, this is what I want, period. And Michael and I discussed, and if you fight that, you don't get anything. I love that piece, by the way, because it's my money, I'm leaving you. So take it or leave it. But let's kind of get into, if you don't have a trust, we have sort of tenants in common, joint tenants, community property. So, I mean, I guess just owning it yourself, right? That's just sold.
Right.
What is the difference between the two most common, which is sort of community property and joint tenants, where say a couple would, I think community property has to be married. Is that right?
Correct. Correct.
Joint tenants does not have to.
Correct.
And both of those have right of survivorship features as long as it says right of survivorship, right?
Correct.
Okay.
Well, correct, but joint tenancy is presumed that it's right of survivorship. The one you're thinking of that is not presumed and there is no right of survivorship would be tenants in common. That's a bit different. So we can get into that separately.
So what would be the advantages or disadvantages for community property with right of survivorship for a married couple? Because remember, joint, they have to be married to do the community property people, but they don't have to be for joint tenants. So let's say somebody's married. What's the advantages and disadvantage of saying picking the joint tenants as you recommend versus the community property with right of survivorship, of course?
You know, some of the family law attorneys will give you some other features of, you know, community property that I'm not qualified to go into because I don't practice in that area, you know,
Okay.
how the community is divided in the unfortunate event of a divorce. So that is, you know, sort of one thing. But for the purposes of taking the title and assuring that your spouse ends up with your interest at your death, either one will work.
Okay.
There are some folks will tell you that the community property interest makes it very clear what you intend to have happen. So there's this step up in basis at the death of a spouse. That will occur regardless. With the tax filings that have to be done. So there's not a significant advantage to taking the title as community property versus taking it as joint tenancy for that particular scenario.
Okay. So in the future, I should just say, hey, take it as joint tenants because the whole step up in the tax basis isn't that big a deal. The joint tenants is, because that's what I used to always do. But then they came up with this community property. So I'm glad.
And a lot of times what you'll see, because people do want to give that nod to, yes, this person's my spouse. It might say, you know, Peggy and Jay Hosking, husband and wife as joint tenants with rights of survivorship. I mean, that's like as buttoned up as you can make it. It's It's not necessary to take it that way, but that might be the way that you do it.
Awesome. Okay. So joint tenants, right of survivorship, community property, married people, right of survivorship is pretty clean. Like one dies, it goes to the other people. If you have 4 joint tenants on there, then, you know, one dies, it goes to the other 3, 2 die, it goes to the other 2. Right. It's pretty simple math, right?
Right.
Now, tenants in common,
that's
it's a little bit more complicated, right? I think joint tenants, you can't. So let's go back to the community property and joint tenants. You can't sort of sell your interest in that property without the other person's approval. Correct. When you're in joint tenants and community property, obviously, because it's, you know, California. But if I do tenants in common, how does that differ from those other two, especially for the ability to transfer your ownership?
Okay, so tenants in common, we often will see more in a commercial context. Okay. When you are tenants in common with someone, there is no right of survivorship. So it could be entity A, entity B, and entity C, all are tenants in common in, let's say, a commercial building that they buy, right? Reasons that people may want to do that, and that may be beyond what your clients are looking for because your clients are typically going to be residential mortgages. But
correct.
but for a moment, it kind of,
But they ask and they try to go to tenants in common, and I always say, yeah, I don't know if that's a good idea in this
right.
context. So
So if you have
understanding the
tenants in common,
context,
right?
yeah.
If you have tenants in common, so going back to our example, 3 different entities, A, B, and C. If B decides, you know what, I'm done with A and C,
Yeah.
he can sell his interest. And now that tenant in common has been, that tenancy in common has now been destroyed. And now there's a new tenancy with whomever is B. So typically you are going to have a separate agreement between tenants in common that kind of directs, can you really sell your interest entirely or not? The reason that commercial people tend to use the tenant in common arrangement, even with that tenant in common agreement, is because they may be interested in 1031ing proceeds from another transaction. So 3, high school buddies who have all made it, they've all had individual properties at different times. They decide they're going to go big or go home. They're going to put all of their money together into one big commercial property. So they each sell their individual properties, but they don't want to pay capital gains on the 3 properties they've each sold. They want to roll that money up into this transaction so they can kick their capital gains down the road for this transaction. But each one owns their interest individually. It's an undivided interest. And each one can transfer their interest by their own estate plans or whatever else they have in place. So if each of them has an LLC, they can put the LLC membership interests into their own trusts and they can pass them on to their kids or whomever. So you may actually have a situation where a tenancy in common could last for more than a generation because the interests have been passed down through someone's estate plan.
Got it. And so, yeah, so let me kind of unwrap this. First of all, what we're talking about can get fairly high level very quickly when we're talking about this kind of stuff. The real estate can be fairly complex, kind of like our tax laws, in fact, tied to our tax laws. Couple resources here on the Straight Up Mortgage Talk. Spotify and YouTube channel is what we talked about with Michael V doing the what is a trust and sort of unpacking that. And then Greg Burns from the 1031 Exchange Company interview that talks about what it, so if you need a little bit of background and you're getting into this more sophisticated stuff, probably listen to those 2 things to have a deeper understanding of what we're going into. So 1031 Exchange just allows somebody who has an investment property, instead of when they sold it after a certain calculation, the profits they made would be taxed at a federal capital gains rate and a state tax rate, which means they could potentially, in today's deal, lose about 30 cents on the dollar for the profit they make. Okay, 20% federal, 9% state. I'm running it to 30. If they sell that property and buy something else, they can roll that through a 1031 exchange into the next investment property and not pay those taxes, utilize 100% of those proceeds. They can't touch any of it without paying taxes, but they can roll it in. And that could be, when she's talking about generational wealth, is maybe your family owns a third of a commercial building. It is paid in full and it spins off $10,000 a month to the heirs, and that's part of their income. So that's how it could be generational. So the 1031 exchange, that's where the tenants in common makes sense because that entity can keep going. It doesn't have to be sold in the trust or any of that. So let me ask you this. So let's say I'm one of this high school crew that's done well, right? I'm buying my big commercial building. I'm rolling in it. My son's going to inherit it. And he says, yeah, I hate this stuff. I don't want to deal with it. I'd rather just cash out. When you're talking about agreements with this tenants in common stuff, you're talking about, yeah, it's tenants in common, and I could actually sell my interest separately. I don't necessarily have to have the approval in a clean tenants in common deal, but I'm probably going to have an agreement with my 2 other buddies of how that happens.
Correct.
First right of refusal might be A and B can buy me, C out. There'll be a contract that a smart attorney like you draws up to protect, so that when that occurs, there was no verbal, there was no misunderstanding. This is how it happens if my son wants to get bought out.
Absolutely,
He
absolutely.
will need to follow that contract or pay a lot of other attorneys to argue the contract if he doesn't want to follow that, right?
Right. And we usually
Got it.
will build in a mechanism for identifying what that value is so that there's no guessing
Got it.
about it down the road.
3 appraisals, take the middle,
Exactly. Right.
something like that. Okay.
Right. And to protect those two, A and B who might be left behind, A and B might also have sort of the ability to approve whomever, or A and C, excuse me, in that example that might be left behind. They might have the ability to approve who buys B's interest, making sure that that
Right, like don't sell it to my worst enemy because you hated
yeah,
me.
that's
Yeah, it can happen. Or
my ex-wife.
that competitor that
Right.
could make our life miserable, like you can't do that.
Right.
So I just thought of a question.
Oh,
So if I have a tenants in common kind of situation and I pass on, right? And I don't have a trust,
mm,
does that go to probate? That piece of ownership?
in all likelihood, it will, because the tenant in common interest, what it owns is a piece of real estate that has not properly been addressed.
Wow. So people have to be really careful
100%.
even after they get trust to and this is one of my questions, and so I'm going to lead into it because this does affect a lot of people.
Right.
So one, they're smart enough to go out and get a trust. So we kind of understand husband and wife, joint tenants, or joint tenants, right of survivorship, community property, husband and wife is joint tenants, right of survivorship, no matter how many joint tenants or whatever else. Tenants in common, most common for commercial, or if you're trying to have separate percentages of ownership, right?
Correct.
So in joint tenant, I'm going to back up here. In joint tenants, can I give different percentages of ownership versus even?
Yes, and I'm so glad you asked that. So
I
one
didn't actually know that.
one way that we
Yeah.
do see that often would be, when you are talking multi-generational, and now you're maybe down to the second or the third generation down. So there might be splits, someone might have a 26% interest or a 25% interest. Somebody else might have only a 5% interest. And yet they can all be tenants in common in the property. So you can have multiple owners, and it does become very helpful from that scenario where each person does have their undivided interest and they can actually transfer that undivided interest. Now, can
But
they
the
buy
interest
higher?
doesn't have to be like if there's 4 owners, 25% each
No, not
in joint
necessarily.
tenants.
In joint tenants, the ownership interests have to be equal, but in tenants in
Okay.
common, they do not.
So that's the one advantage of tenants in
Right.
common is that I can own 60% of it. And if
Right.
my partners can only afford, I'm making myself the big wig here now, I get the 60% and they can each afford the other 20% each.
Mhm.
That means that my family would still get that 60% in the future. And that's the biggest reason for tenants in common and why it's most likely used in commercial is
Mhm.
because you can have that separate percentage of ownership versus equal shares in joint tenants and community property, right? I mean,
Correct.
property is sort of a 50-50 thing unless we start allowing people to have more than one husband or wife, right? So I guess, because I don't know, otherwise it's community property is usually 2, right? Am I getting that right? All right, that's a different day. So on the, okay, so they've got the tenants in common. We know we have to have a trust. Now we're going into the question that I run into, and you probably run into where the horror stories start, which is I got a trust. I was smart enough to get a trust, but I either one, refinanced with somebody who didn't put me back in the trust to make sure I was back in the trust, or 2, I failed to put my properties in the trust. Like I bought a property down the road. Probably your attorney's smart enough to make sure that you got put in the trust. If you're smart enough to use an attorney instead of some of these other things, they make sure that they get that recorded in the trust. But like, we're just talking about property, but there's other accounts like savings accounts and large things like that should be in the trust too. But what happens when somebody, let's just take them piece by piece. One, I got a trust, but I bought another property 2 years later and I didn't make sure it was recorded in the trust because the mortgage company didn't allow it.
Right.
And I didn't go back to my attorney to put it in there. Or worse, I refinanced a house and didn't put it back in the trust
Right.
because they took it out of the trust because they didn't know how to close in the trust.
Absolutely. So again, back to the gold standard. The gold standard is every time you change title to a piece of property, every time you finance it, double check, make sure it's in your trust. Okay. So that's your gold standard with respect to if you have a trust, how to hold the property. If you have a trust and you do this refinance and you forget to put it back in, and then unfortunately you pass away, there is a petition that can be filed called a Hegstead petition. And I'm sure Mike talked about this a little bit. I don't recall from listening to his video.
I don't think he did.
But the idea is when you draft a trust, and the way most people draft the trust today, it will have language in it which specifically authorizes the trustee to file this Hegstead petition, which says we can identify that the trustor's intent was for this property to be in this trust. So even if they goofed it up, they forgot to put it back in, here, court, please take a look at this, see the evidence we have that shows that this was the intention. And most of the time, if you have that kind of evidence, then the court is going to say, yes, this was supposed to be in the trust, and therefore the trustee is now authorized to administer it however the trust allows for it to be administered. And that will, again, avoid going to probate, which is our big reason for using the trust.
But again, a lot cheaper. Call your attorney, close in the trust, make sure it's back in the trust. Otherwise, when you say court and you say attorney to fix these things, you're talking extra cost,
yes,
which of course is good for your business, but you'd rather help people do it right the first time because then it's a lot smoother for their families and all that good stuff. Okay. So that's exactly kind of what I want to know. So once they sort of put it in, they don't put it back in the trust. So I'm going to get into the fun part of this because I think people should kind of understand like why they would do the different deals. And now I'm going to be telling people do joint tenants instead of community property. It's a better way to go. But horror stories, when people either don't have the trust or the horror tenants in common, give me a couple of examples of the kind of stuff where people have to pay you big bucks to sort of wrangle their situation or try to fix it, or where you have to tell them, yeah, you screwed up, not much I can do.
So one that comes to mind is a gentleman thought he was maybe a little bit craftier than the average fox, didn't want to pay an attorney, decided that he had some creditors that were after him, so he was going to put his house in a trust. So he went to the recorder's office with the deed, and he went to transfer that house into a trust, and he just made up the name of a trust. There was no such instrument. And the recorder's office said to him, well, gosh, you have to have the date of the trust. So he put in the date that he was recording the deed. Okay.
Created the trust and recorded the trust that day. Very efficient attorney. Very efficient unattorney.
Exactly. Very efficient unattorney. But as it turns out, unfortunately, there was no trust.
Let me ask you a question. That trust gets recorded, right?
Not the trust instrument. The deed transferring it to the trust. All the deed is a document that goes to the county recorder that says ownership is now held this way.
But you have to be able to find the trust somewhere.
When he dies, you have to be able to find the trust, and there was no trust to be found. So what happens, unfortunately, is the title company, when you go to sell that house, says, hey, wait a minute, who's the trustee? Who has the authority to sell this property?
Meaning they asked us for a copy of the trust before they will do title insurance and they say, look, where's the trust? We have to make sure and so does escrows, right? We have to make sure we're following the instructions, if I can call them that, of the trust. Absolutely. So we need the trust.
Right. And when you can't produce the trust, then guess what has to happen?
Probate.
Right back to court. Right. So that's a really unfortunate one. He had a couple of other errors that have made it just really unfortunate and challenging, including the fact that we believe there may have been a will for his wife. But when she died, he didn't think he needed it anymore because, he was the husband and he got everything. So he just threw it out. So that makes it challenging as well because there is a difference of the ownership there. So, yeah, please put it in the right way.
Tell me, I'm assuming like in the tenants in common stuff where people don't have the legal documents saying what should happen written very well, that you end up with a lot of suits and stuff. Anything that comes to mind with, because I can imagine you have tenants in common.
Same
It's
exact,
not like family, which I don't know, maybe that's better sometimes. But if the language isn't clear, like you stated before, about what has to happen, how the thing's going to be evaluated, I'm assuming there's a lot of clusters in that arena.
right. Well, and in fact, that same gentleman, when he and his wife bought the property some 40 years earlier, how did they take title? Tenants in common.
Oh, husband and wife. Interesting.
So they bought the property together as husband and wife. They took it as tenants in common. He makes this transfer with both of their signatures into this trust that doesn't exist. So he screws up the title from that perspective. So we've got to deal with that. But now, because they took it as tenants in common and they didn't take it as joint tenants with rights of survivorship or as community property, she could theoretically have conveyed her interest away without now having a will that maybe said it was a pour over will and would go into this mysterious trust. We now have to probate not only his half interest in the property, but hers as well.
Oh, wow. Because it's not right of survivorship. So I never
Correct.
really transferred to him.
Correct. So this has become, unfortunately, for the lone survivor, this has become an exercise in just absolute frustration because she's, of course, out of state. The property is here in California, so she's trying to deal with this, and she's been working on it for a year to clean up the title. And she has buyers who want to buy the property, and she's looking at the market saying, "I really want to do this before the market crashes."
And she's super lucky because it's only her.
Yes.
So, I mean, we could have in a
Right.
lot of these situations, tenants in common a lot of times like that, where maybe the people were previously married, had kids from separate marriages, and the
Exactly. Oh my
language
gosh.
isn't clear. And who's fighting for that tenants in common? Was that supposed to really go to the husband and the husband's family, or should have that really gone to the wife's kids? And that's the so this is where trusts spell it out, contracts with the tenants in common spell it out,
Mhm.
not having it. What is it? One of my consultants say, being unclear is unkind. So, right. And that's what
Yeah,
attorneys do really well, is making sure that you button up the clarity.
right.
Well, what is this? Asking the questions. Well, what about that? Well, we haven't thought about that. Well, you need to.
Yeah.
So, and how, who's this going to, and how do you want that to happen? Well, we didn't really want to talk about it. Well, do you want to leave it as a cluster and all the kids hating each other or whatever, or business owners hating each other? Would you like to like spell it out? Something I learned early when my brother helped me qualify for my house when I was too young to afford it, and luckily he's a great brother and we were able to get past it, but there wasn't sort of the written clarity. I learned that at an early age to make sure things are in writing.
Mhm.
Um, any other sort of horror stories or
Sure,
things that you think, hey, people should watch out for in
sure.
just life in general when it comes to things that are going to cross your desk because it wasn't done right?
Absolutely. So we had a husband and wife and a third party who bought a piece of property together. And they thought they were being creative. They wanted to be joint tenants with rights of survivorship. Okay. Husband dies. Well, remember, joint tenants, everybody has an equal interest. So
Correct.
everybody had a 1/3 interest. So
Now
when
it's
he
50
died,
50.
now it's 50-50 as between the survivors. Of course, one of the survivors is unsatisfied with that because she was married to husband. She wants to say, no, she gets 100% of his interest, but she does not.
Not legally,
Not legally.
right?
Not legally. So again, in order to clear up the title,
Mhm.
you get to come see me and I she's one of my litigators who will be only too happy to help you with this, but unfortunately you will have to
At a
have that
fee.
privilege. Yes. Yes. So that's
So
one.
something I forgot to ask, and I've been told you can't do this, and so prices in California are fairly expensive. A lot of times families are involved in these transactions.
Right.
And maybe your parents going to help you with the down payment because, like me, I didn't want to move to Kansas to follow my son where he could afford to live. or whatnot. We got these things that are so expensive now that a lot of times kids are getting help in purchasing that first property. Parents have had a lot of equity build up, or they're just, want to keep grandkids near or grand doggies or whatever. So but of course, older, kids younger. And so we have a trust.
Mhm.
But my understanding is that you can't sort of hold like a trust, and a trust can maybe hold a property in joint ownership, but a trust can't hold joint tenants with like another person. So
Correct.
can you
Because a
explain that a little
trust,
bit?
sure, a trust isn't a person. So the
Entity.
whole concept, it's an entity, correct? It's
Got
not
it.
a person. Um, in the concept of survivorship, and that's where this joint tenancy comes in. It would be as survivorship. So the trust itself doesn't die just because
Oh,
it dies.
first one to explain it to me. It totally makes sense now. Well, because it's an entity like a corporation. The corporation
Correct.
doesn't die. It gets closed out eventually, but it doesn't die. Makes sense.
Right. So there's no limited, survivorship on that one.
So
Now,
for example, then you would just do joint tenants, or you would get two trust, or can you
so
do, can you do joint tenants with two trust?
no, again, the joint
No,
tenancy isn't going to work because again, the
because it's right
trust
of
lives
survivorship. You
forever.
can't
You don't
die.
have that idea of survivorship. However, you could do it as tenants in common. So dad and mom and dad in their trust could own part of the house. Whatever the interest is based upon what their
Oh, got it.
contribution is. And then son or daughter or whomever you're helping out
Mhm.
could be the tenant in common. And they could pay the mortgage and do all of those kind of things. But typically then, of course, the lender is going to want everybody on the trust, which makes mom and dad on the hook for more than just their down payment if child doesn't pay.
Got it. So here's another thing, and I think you're going to tell me tenants in common is the way to do this. So mom and dad, so young couple,
Mhm.
super in love, just got married,
Oh,
but one family, and we know there's like a 50% success rate because I've been around a while,
I
and God forbid, I
think
know
those might be
statistics, and I
optimistic
know this is,
numbers.
I know, right? And I know this is never going to happen to you, but your family's putting in 200,000 of the down payment,
Mhm.
and probably if things don't work out, like there's maybe your family or you is going to expect to sort of get your initial investment back, and then of course whatever the property makes being shared, because that's fair, even though that 200,000 reduced the payment and all those things. Those are other factors. But how does one make sure, what's the best way to hold title or document? Because this is fairly common in our arena here, right? That maybe their family's investment in that property is protected because technically the parents are giving their inheritance to their son or daughter, not really to this other person they've known for 6 months or a year. The intent, especially if things go south, is that that would be, inheritance or family transfer to your child.
So there's two ways that you can do
Okay.
that I can think of off the top of my head. The first one is we can create a separate property trust for whichever child is receiving money from their family. That is a gift from their family. It goes into their separate property trust. It is not part of the community. They're not commingling with the community. They take title to the property as tenants in common. They take title as Jane's separate property trust and Joe, tenants in common, each as to a 50% interest. In that way, then if something happens to Jane, whatever her trust says will control what happens to her portion of that. So if she dies and her trust doesn't say it goes back to mom and dad, but let's say she has kids or she brings kids to this arrangement, then her assets are going to follow through the trust and go to her kids.
Again, we talk about remarriages and stuff too. So this is a good example of that too. The same thing, right? Where you get together later in life, but you don't want that to go to your 20-something younger wife. You want it to go to your family. And
I actually just met with a couple who are both have been married before. Their children are all adults now. The house is in her name only. and he has a business that he is concerned might have creditors. So they don't want to put the house
Got it.
into the community. They don't want to have it with joint tenancy with rights of survivorship. So it will go into her separate property trust. And she'll keep
Interesting.
it that.
All right, what's the other way?
The other simpler way to do that is to simply do a loan. So the mom and dad who are giving the money, they give the money, it is vested there for, whatever period of time is necessary for the financing, which is of
Meaning
course,
we have to show it as a gift,
right.
right?
So it
And
has
it's
to, and it has to
technically
be-
for all purposes is a gift unless something goes south, you
Right.
owe us, right?
Right. And so then you can do a loan instrument that goes back. And if you want to secure it, then you would record a second or third trust deed back to mom and dad for that.
So just showing, because I've always said, hey, you should probably keep proof that this down payment portion came from your family,
Yes.
and I have them write the gift to their son or daughter only,
Yes.
not to the joint.
Yes.
Is that another way to sort of prove? And I say as early inheritance, because
Yeah.
inheritance isn't shared. Is that like and then we're going to get into it. So I don't forget the cheap trust, which is the joint tenants and transferring property over, right? That
We'll talk about that in a second.
Right, but don't let me forget that. But I mean, is that kind of enough documentation that would be like, look, this was for him or her, that $200,000 was early inheritance to help our son or daughter out? I mean,
you want to have that documentation. You also want to be careful not to then keep refinancing the property, right? Because then all of a sudden it's starting to get commingled. It's going to be much more difficult for the family law attorneys and their expert accountants to unwind it and make sure that those things were not commingled. So the more documentation, the better. It seems very unromantic to deal with that on the front end. However, families do have a vested interest in making sure that if the relationship doesn't work, that nest egg that they gave to their child is still available for their child.
And not a lot of people have a couple $100,000 laying around, that's not like something, I mean, or 50,000 or whatever it is, that's a big deal to most families.
Right.
And it is like them giving a piece of them away. I mean, it's to really help their child out, especially if something goes sad, unfortunately sad and bad and all that. So I'm glad you said that, because it was funny, the whole tenants in common and that kind of thing makes a lot of sense. But probably you might be sleeping on the couch for a while, whoever you just
well,
I mean,
honestly,
but when people don't do this stuff and things go bad, it'd be better to sleep on the couch for a week than have like this 200,000 that could have really helped and now you don't like this person anymore. They're not all amicable, we found out. Yeah, I mean, it's better to protect yourself in some form or fashion than just assume it's going to be the happy ever after. When there's like a 50% fail rate, like that's an F grade, right?
Absolutely. Well, and here's the thing. I mean, if your spouse to be is not understanding of this, then you have some soul searching you should be conducting at that moment. And
you forget these people are young and in love. Please, you're talking like an attorney,
used to be that before you could get married, you had to go through marriage counseling, right, to make sure you were compatible. We don't do that so much anymore. Maybe that's not a good thing.
Yeah, I agree with you, and it's spoken like people who've been around a little bit and seen it go south, and you've probably seen more than I do. But in my business, I see it a lot, and your business see it a lot. So sort of protect yourself. All right, we got to finish this up because you're
joint tenancy, before we go away, sometimes people will use a joint tenancy as a means to transfer the interest from one generation to another.
Yeah, that's what I want to talk about. I call it the poor person's trust.
Yeah. So, a trust doesn't only deal with real estate, first of all.
Correct.
There can be other things that are in the trust, whether those are life insurance proceeds, large savings account, that sort of thing. Typically, if someone is going to use this joint tenancy, so let's say it's mom and daughter want to be entitled together for joint tenancy.
Let's go back. Mom bought the house for $100,000.
Okay.
2015, it's now worth 400,000.
Okay.
And mom decides instead of doing a trust, she's just going to add her daughter to the trust. In 2015, it's now worth 400,000. Remember, mom had bought it for 100,000, right?
Right.
It's now worth 400,000. Now mom dies and the property's worth 700,000. That's where the problem, I understand, occurs.
Absolutely, 100%. And thank you for giving such a great
I
example.
just need like an example so people can get like, mom bought it for 100 grand.
Right.
Daughter goes on at value of 400 and now it's worth 7.
Right.
How does that impact the deal?
If mom had done a trust, then daughter would have a step up in basis when she received her inheritance at mom's death at the value of $700,000. But if daughter comes onto the title as to basically 50% of it at 400,000, mom's basis is still 100,000. So when mom dies, so now you have to split the whole thing in half. And I'm sorry,
because you gave away 50% of your property, right?
Right.
So you've given 50% of your property away in 2015 at 400,000.
Correct.
Okay.
So basically, daughter now has a basis of 200,000 in her 50% of it. Mom's basis is still 100,000. But now, fast forward, mom is selling, mom dies and daughter is now receiving mom's half interest. But the basis in that is still $100,000. So there is capital gains to be paid on the difference between half of $750,000, so
700, 350.
700. Okay, so 350 less than 100,000. There's capital gains be paid on $250,000.
So, because they were just put on title, and now 250,000, which is talking about capital gains, that means 30 cents on the dollar. I got my calculator here because I'm a lender. 250,000, again, the same scenario, 20% federal, 10% state as of the date of this deal, means that now they're going to get rid of 75,000 that goes to the government.
Yep.
And not to your family and loved one, because you decided not to spend 2 or 3 grand getting a trust.
Correct.
Right. And 100%. You still have, because you've got the joint tenants, okay, you get the right of survivorship, but you don't have all the other assets, savings account, checking, these other things that could be in the trust too. So I really wanted to go over that because I actually didn't know that for a number of years until one of my CPA friends mentioned it. And I was like, holy crap.
Yep.
It's very common for people to just add them. And I didn't realize that.
Yes.
Said it. So when we talk about a step up in the tax basis, what that means is that if, whether it's a rental property, and you can correct me if I'm wrong, or owner occupied property, if I bought it at 100,000, let's just make it an investment property. If I bought it at $100,000 and I sell it for 500,000 and I'm married, I have 250,000 per individual that's tax-free if I own it and live in it. If I go and buy it as an investment property and sell it, depending on what the cost I pay, the cost to buy and sell, any fixing up, I'm going to come up to some pure profit number, which is subject to capital gains, me as the person living now.
Right.
But when I die, my family member gets a step up in that tax basis to the new value. So they don't have to pay those capital gains unless I've been dumb enough to give 50% of the property way long ago. They get to sell that property and not pay that 30 cents on a dollar, not only on investment properties, but on the primary residence as well. So there's a huge advantage until you get up to an inheritance level of what is it, 10 million now?
11.2 per person.
Okay, 11 million to per husband wife inheritance.
Right.
So
right now, I mean, we are expecting that to be rolled back, right?
Right.
Sunset.
So if you haven't figured it out, the tax system was set up for the rich. So even though Prop 19, that is a great thing to listen to, that Peg and I went into, that was the property taxes are going to reset. There's a lot more people are probably going to sell their properties because of that, because that inheritance now doesn't get to keep the same property taxes, but there's still that caveat that they still get to inherit. If they sell it, they have that step up in the tax basis. So trust. If you don't understand that, understand the risk of the joint tenants and what to do. And as Peggy said, you get the dang trust within a year. And yes, it is nice to think you will live forever, but probably not going to happen. So good thing to have a trust. But
And I'm just going to plug one more thing on that.
okay.
So the trust, yeah, we're talking about that in the real estate context, but typically when you're sitting down and doing your trust, you're doing the rest of your estate planning documents. And Mike, I'm sure went over this with you, where you're talking about the durable power of attorney for healthcare. That's really telling your family members how you want to be treated when you cannot make those decisions yourself. And that's a horrible time for families. So please do the trust, do the durable power of healthcare, do the statutory powers of attorney, all those things that can help you.
And if you're younger,
handle it.
where your kids are supposed to go, who
Yes,
should be taking
please.
care of them,
Yes.
like all these things that you let the wishes be known, right? But
Right.
the power of attorney one for the healthcare directive is so critical. It's like, no, son, you don't have to feel guilty about pulling the plug because I want you to pull the plug. Please pull the plug, because if I'm brain dead, I don't want you to spend everything I've worked for that I would love you to inherit on the medical care, and I'm sitting here in a vegetative state. I want to go out fast and furious. Please,
Right.
baby.
Yes.
As my
Absolutely.
mama says, if I have some sort of degenerative disease or cancer that's going to kill me, just put the dark chocolate covered ludes by the side of the bed. I will take care of the rest. You know, I do not want to live, right? That's my mom. She's a realist. Like, nope, I will take care of it. So
Exactly.
Peggy, thank you so much. This has been, as always, so informative. When I interview people way smarter than me. And so I appreciate so much your time. And I know you're slammed, so it makes it even more important that and sort of an honor that somebody at your caliber would take the time to help us all learn more. So I thank you so much.
Thanks so much, Tim. Always a pleasure to chat with you.
Awesome. Thank you.